Good morning, colleagues. We are start today our next event from series of digital economy, and today we'll speak about ethical and legal aspects using artificial intellect in Ukrainian economy. And our first brilliant speaker will be Dr. Olena Chaban from University College of London, with expert opinion about new artificial intellect regulation in European Union. So, Olena, welcome to your speech. Thank you for participation.
Thank you very much. Shall I switch to my presentation myself?
Yes,
yeah.
Yes,
okay.
You have it.
Now I don't have access to do that, sorry. The Bar Association shall stop. It's, yeah.
Зараз. Віталій, включіть, будь ласка, права доступу.
Yeah, it is working now.
Thank you.
Okay, I'll start in Ukrainian just to greet everybody in Ukrainian, and then I'll switch to English language. Добрий день. Перш за все, дякую організаторам за запрошення виступити сьогодні з доповіддю, а також шановним учасникам за те, що приєдналися до цього заходу, за вашу зацікавленість, ваш час і за вашу участь у заході. Моя презентація буде англійською мовою і сьогодні, і я завчасно хочу вибачитись через те, що виклад матеріалу буде дуже стислим і, можливо, наприкінці не буде достатньо часу для того, щоб отримати повний фідбек і відповісти на всі запитання, тому що в мене вийшла накладка і мені потрібно буде закінчити набагато раніше. Зараз я переходжу на англійську для презентації. Дякую завчасно за увагу. So let's start. I will provide a brief overview of current choices of Ukraine to the avenues to regulate the AI, but it will be delivered through the prism of world trends, of world progresses. We all know that artificial intelligence is a multifaceted creature, penetrating all spheres of our social life, and it is integrated across various sectors, from genomic health prediction to warfare, fostering innovations and a rapid tech development. According to the marketing research led by Kantar Ukraine, reflected in the white paper issued by the Ministry of Digital Transformation of Ukraine, over 78% of respondents in Ukraine know what AI is, and over 29% of respondents confirmed that they use AI in one sphere or another. And according to the survey of IP Source, it's a French-based research company, but it is represented globally. It's a huge company. According to their survey, cited by Stanford University Human in report dated 2024, people across the globe are more cognizant of AI's potential impact, but at the same time, they are more nervous about AI. And this report is brilliant from the point of view of statistical data and information. So if you're interested in different jurisdictions and statistics per countries, from different perspective, you may check this report. It's very brilliant and interesting and informative. So I really recommend it for those who are interested in AI and figures statistics. from the point of view of policy making, we are witnessing that AI is capturing the attention of policymakers worldwide. In particular, last year, I'm sure most of you, even everybody knows, in November last year, the World First Agreement to Pledge the Declaration was endorsed in the UK, and proudly, Ukraine was part of that event. So Ukraine was among the 28 countries, including the US, Saudi Arabia, China, the UK. And it was a big event, big meeting of different countries, leaders of different countries, and the first world agreement on AI was endorsed. Generally, last year and this year are marked by a lot of legislative initiatives. And again, according to the report by Stanford University Human, AI was mentioned in the legislative proceedings of 49 countries this year. So this year, I mean 2024. But in 2023, the USA witnessed a remarkable increase in AI-related legislation at federal level. We're not talking about AI legislation as such per se, but AI-related legislation. And as for AI-related legislation, 181 bills were proposed in the USA. And I'm sure most of you heard about California AI Acts that were enacted this year. They're quite controversial, but still they are not on federal level. These are California acts, but still some states already are moving towards having the separate legislation which will regulate the AI sphere in a more rigid way, not in a soft way. Last year, Biden-Harris administration issued executive order on safe, secure, and trustworthy AI. And that happened last year in October. And it was very relevant to AI industry because the document produced some kind of soft approach to make the industry aware of main principles and recommendations for AI being safe and trustworthy. Again, the executive order is available on the website of the White House. If you're interested, you may check it because it's the only one. It's the only document that is more or less on federal level and has this soft approach. This year, the so-called Chevron doctrine in the USA again was abolished by the US Supreme Court. And Chevron doctrine is a rule created by a precedent, by case law, according to which initially the judges couldn't decide on issues that required technical expertise, some special knowledge. So they had to refer to some expert opinions. And this year, the US Supreme Court overruled this precedent. So it's a very hot topic in the USA nowadays because potentially it is not related directly or exclusively, I would say, to AI, but it is it is related to AI because everything that is to do with AI will refer to some technical knowledge and expertise, and potentially this will open floodgate for new bits of legislation when legislators will have to correct the approaches of the courts. And you all know that in the EU, in May 2024, European Council approved the Artificial Intelligence Act, giving green light to the first so-called worldwide rules on AI. And I will not be talking about it because we have a speaker today, honorable expert Tatiana, who will focus on this topic more in detail. As for the UK, in the UK, in His Majesty's most gracious speech to both houses of Parliament, His Majesty referred to the key legislation that the new UK government will focus on, and among others, the AI relevant law was highlighted. At the moment, again, there is a soft way to regulate the sector in the UK by white paper, but the main idea, the main focus is safety. The future of AI is the safe. AI is kind of a mainstream, main focus of the approach of regulating the AI sector. And there are also 5 essential characteristics identified for regulatory regime: pro-innovation. The regulation shall be also proportionate, trustworthy, adaptable, clear, and collaborative. In the UK, there are few bills submitted by previous government and private members bill also, but they are not going forward. And this kind of forbearance from legislating is explained by the elections, by the new government. We see lately this kind of wait-and-see approach, which is similar with Ukrainian approach. So there is a soft way, and this soft way provided by white paper buys some time for the experts and also government policymakers to think, to see how the regulation works in other jurisdictions, in other countries, and to work in the meantime on the bill. But again, this wait-and-see approach cannot be long, and this is relevant for both Ukraine and the UK. Otherwise, especially for the UK, as UK is classed as one of the leaders in the AI, and from the point of view of public investment as well, from the point of view of private investment into the AI sphere, the USA is a leading country. But UK, from the point of view of public investment and public attention to the AI. So this wait-and-see approach cannot be long, cannot last forever. Otherwise, the industry will start to adjust more and more to the EU law. And according to the experts, the UK may lose its control over the sphere. So for the UK, it's crucial also to produce a sensible and comprehensive legislation. But at this very moment, there is an information from the experts that experts are working on the bill, but nothing is available at the moment to discuss more in detail, because those bills that are submitted and are available online. They're not going forward as far as I'm aware of. And today also we will be looking at the approach of Ukraine, how Ukraine is regulating or plans to regulate AI. The importance of a sensible approach to the said regulation is undeniable for Ukraine, and perhaps even greater than in any other jurisdiction due to both wartime context and perspective, Ukraine's economic recovery. In June 2024, the Ministry of Digital Transformation of Ukraine issued the white paper on artificial intelligence regulation, and relevant policies were also issued by the Cabinet of Ministers of Ukraine. The most recent one is dated 13th April 2024. These soft approaches aimed at preparing various industries for the legislative vector. And again, I'll not be talking much about the white paper because we have the honorable representative from the ministry who is present or will be present here today and will be available to produce comments and answer the questions. But what struck my attention is an approach to the defense sector, which in my opinion is very sensible, very reasonable. According to the white paper, defense sector is not to be the subject of the regulation. And this is due to both the national interests of the state and the real state of affairs in the security center. So the opinion is that providing regulation of AI in defense sector within an ordinary act, within an ordinary law, will be detrimental for Ukraine as a country which is at war on the one hand, but on the other hand, the experts who delivered the white paper, they confirmed that still some rules are requisite, and what they offer this to be done through conventions at the level of international humanitarian law by developing the relevant conventions, like new conventions, or updating the existing documents. Currently, at the same time, there is also a need to have a specific legislative instrument, considering Ukraine's existing obligation to align its legislation to the European standards. So on the one hand, we see this soft approach in Ukraine, like in the UK, but on the other hand, Ukraine is not pressured, but it has an obligation to harmonize the legislation with the EU law on the one hand. On the other hand, I very much liked the statement of Minister of Digital Transformation and Deputy Prime Minister of Ukraine for Innovation, Science and Technology, Mikhailo Fedorov, that harmonizing the relevant law with the EU is not only the formal requirement, but having identical legal regimes will also facilitate to attract the investments to the Ukrainian market, which I completely agree with. So to sum up, I would like to reiterate again that regulating the AI is, let's say, a multi-million task for Ukraine. The sphere is very promising from the point of view of prospective investments. So regulating it will be a very demanding process as the stakes are really very, very high. So thank you for your time. And I'm sharing my contact details if you have any feedback or you would like to have some information from me, if you have any questions, you're welcome. I will be happy to be contacted. Thank you.
Thank you. Thank you, Olena, for your brilliant presentation. And as our main goal today, talk about impact to economy and looking for best approaches and best way using artificial intelligence regulation. For your opinion, that way most right, most wise in Ukrainian case, fast revolution or wait and see, or maybe we can find our independent position in this global changes as it's in British tradition, or we will go into adaptation our legislation according to European Union and together with European Union. That is the best approach for your opinion.
Thank you very much for your question. It's a very good one. In my opinion, a wait-and-see approach at this very stage is very sensible, very reasonable. But as I mentioned, and it's not only my opinion, but a lot of experts share this view, wait-and-see approach cannot last long. So we are very much following the same approach as the UK at this very moment, like wait and see. But on the other hand, we don't have enough time to produce quality legislation very quickly. So this wait and see approach gives some space, some time to work on the bill and to produce a quality law. And it's very important to be reasonable with rules, not to make them too rigid. Otherwise, it may impede the development of economy, which nobody wants, yeah, because, especially Ukraine. Like nobody, no jurisdiction wants to impede economy and development and progress. But at the same time, rules are important. So wait and see approach is a very sensible approach, as as I have mentioned. But at the same time, we need to produce law, and I don't know if we can choose not to do that, because there is also an obligation of Ukraine to harmonize the legislation, not particularly the AI Act right now straight away, because it's not even in full force in the EU at the moment, but still, so there is this obligation to have the similar legislative regime with the EU. And of course, Ukraine is welcome, I think, to follow the examples of other jurisdictions, perhaps to insert some rules, or maybe on policy levels, maybe from the point of view of structuring different obligations, from the point of view of regulator. Ukraine is welcome to just learn about experience of other countries, take the stock of experience, like the best examples, and then to implement. So that is my position.
Thank you very much. It was a brilliant presentation from Olena Chaban, Honorary Research Fellow, University College of London, Ukrainian advocate as well. Olena, thank you for your participation. And I pass the word to Tetiana Gudima, Dr. Tetiana Gudima, from our co-organized organization, Institute of Economical Legal Research, National Academy of Science, name it Valentin Mamutov, with presentation about Ukrainian view and most European view about artificial intellect regulation. Please, Tatiana.
Alexander, I can share my presentation.
Open up to you.
I will leave now and I will close my presentation.
Yeah.
So thank you very much. And sorry, I must go. Thank you. Bye.
Yes, yeah. Olena, close your presentation and Tatiana will open our own. Oh.
A minute. Okay.
Great.
First, I would like to begin by expressing my sincere gratitude to Alexander and the event organizers for kind invitation and the opportunity to speak today. I also extend a warm welcome to all of you attending this roundtable. I trust that this event will provide value, insight in and deepen your understanding of the evolving regulation landscape for artificial intelligence. In my presentation, I will explore the features of AI regulation, focusing on a comparative analysis of the Council of Europe's AI Convention and the EU AI Act. Let's start. As you know, after nearly 2 years of dedicated efforts, the Council of Europe adopted the Framework Convention on Artificial Intelligence, Human Rights, Democracy and Rule of Law. The treaty was open for signature on September 5, 2024, with the first 10 signatories: Andorra, Georgia, Ireland, Israel, Moldova, Norway, San Marino, the United Kingdom, the United States, and the European Union. This historic document marks the beginning of the world's first legally binding international agreement focuses on artificial intelligence. The framework centered on the protection of fundamental human rights, the promotion on democratic principle, and adherence of to the rule of law in the realm of AI technologies, set a significant precedent for global governments in era of intelligent machine. In recent years, notable shift in global AI regulation have occurred, significantly accelerating in the past few months, following the lead of the European Union and its landmark Artificial Intelligence Act. Countries like Canada, Brazil, Australia are involving preliminary legislative framework that adopt a risk-based approach. The well-known brutal effect has even influenced major powers such as the United States and China. The former albeit through executive order is gradually moving away from its handoff stance, comprehensive framework to standardize its sectoral legislation. And while the latter has announced a plan to develop a framework to standardize this legislation, the same legislation. While this mosaic of regulating seemingly signals the end AI Wild West era, a pertinent question arises regarding how these standards align and interact with other frameworks, such as the OECD's principle and UNESCO principle and values, among others. Let's begin with some key differences and overlaps between the Council of Europe's AI Convention and the EU AI Act. They represent two examples of binding legal instrument. In other words, unlike the ethical frameworks provided by UNESCO and the OECD, both are legally binding. The first one is legal nature and enforcement. As you know, the EU AI Act is a legislative act of European Union issued through the ordinary legislative procedure. Like other European Union regulation, it is a type of binding legislation that applies directly to all EU member states. And in contrast, the Council of Europe's Convention is an international law instrument that is binding only on the countries that sign it. These countries will be required to implement its provision at the national level through the enactment of domestic law. In essence, while the provision of the AI Act take direct effect after a specified period, the Council of Europe's AI Convention preliminary emphasizes the obligation of its signatories to ally their national legislation. Ultimately, this ensures that citizens can defend their rights and seek redress for any violations. The next one is regulatory authorities and scope. The European Union is a vote-only economic and political union consisting of 27 member states. Once the AI Act will become binding for these countries. In contrast, the convention is in contrast, the Council of Europe is a human rights organization that comprises 46 member states, on which 27 also belong to the European Union. Additionally, it has 5 observed states, including the United States, Japan, Israel, Mexico, and Canada, which are not bound to the Council of Europe, but may sign the AI Convention, committing to follow its rules. Given the active involvement of these non-European Union states in the negotiation process, it is highly likely that they will opt to join. The next one is objective. Regarding the Act, its Article 1st establishes the objective of the regulation to improve the function of internal market and promoting the uptake of human-centric and trustworthy AI while ensuring a high level of protection of health, safety, fundamental rights enshrined in the Charter, including democracy, rule of law, and environmental protection against harmful effect of AI system in the Union, and supporting innovation too. The AI Act doesn't contain provision regarding the rights of the data subject and the individuals affected by AI system. It doesn't recognize enforcement mechanisms for individuals, including procedural rights and rights to appeal or seek compensation or complaint mechanism. Furthermore, it overlooks the broader societal impact of AI, neglecting the public and civil society rights to information and participation. Instead, the AI Act focuses solely on differentiating obligation for developers based on the risk level of the AI system, thus narrowing its focus and scope. On the other hand, the provision of the convention aim to ensure that activities through the AI system life cycle fully comply with human rights, democracy, and the rule of law. Essentially, while both instruments prioritize the protection of democracy, fundamental rights, and rule of law, they differ in their specific focuses. Their format concentrate on regulation, the marketing of AI product in the European Union internal market, whereas the AI Convention focuses on protecting the human rights of individual affected by AI system. The convention is based on principle and unlike the AI Act will introduce legally binding individuals' human rights that will also apply to citizens of non-European Union countries. The next one is scope and exception. Article 2 of AI Act establishes that its provision apply to providers and employees who place AI system in Union and whose system outputs are used in the Union. This also includes importers, distributors, and others. While users of AI system are covered, the regulation primarily focuses on providers, entities that develop AI system and place them on the market or employ them for their own use. Based on this, it can be concluded that the AI Act doesn't apply to private end users, as Article 2 explicitly exempts developers from obligation regarding the use of AI system in a personal and non-professional context. Regarding the Council of Europe Convention, its scope covers activities throughout the life cycle of AI system that may potentially interfere with human rights, democracy, and the rule of law, including activities by public authorities or private entities. The document then establishes that each participant country must specify its approach to fulfilling this obligation, either by applying the convention principle to private sector activities or by taking other appropriate measures without derogating from its international obligation and without any restrictions. About exception, there are two key exceptions to the application of AI Act, which include system used exclusively for military purposes, the defense or national security, and also systems specifically designed and deployed solely for research and development purposes. Critical remarks have been raised regarding the exclusion of AI system for military defense and national security from regulation, as this could lead to human rights violation. While Slovenia justifies this exclusion based on international law, the AI Act objective is to create horizontal legal framework for the market integration of AI with minimal general rules, not to regulate national security policy. Nevertheless, a risk remains. In a specific case, AI system could be identified as being used for national security purposes to avoid legal regulation on the AI Act. This, in turn, could result in human rights violation, as such system may be repurposed or used without proper oversight and safeguards. The convention also includes same exception. A party is not obligated to apply the treaty to AI system related to the protection of its national security interests, provided that such activities are conducted by applicable international law, including international human rights obligation and with respect for its democratic institution and processes. Furthermore, the Convention doesn't apply to research and development activities related to AI systems that have not yet been made available for use, except where testing or similar activities are conducted in such way that they could potentially infringe on human rights, democracy, and the rule of law. The next one is artificial intelligence definition. The slide presents two approaches to define artificial intelligence, which I want to read out loud. As you can see, moving towards standardization, the draft framework convention aligns with the OECD by adopting the same definition for artificial intelligence systems. This consistency is crucial for clarify and coherence in international AI discourse and regulation. Similarly, the AI Act has finally adopted a comparable definition. The draft text has been revised as the previous definition faced criticism for being overly broad and encompassing a large portion of contemporary software. And the last one, remedies. Article 85 of the AI Act stipulate that without prejudice to other administrative or judicial remedies, any natural and legal person who has reason to believe that violation of the regulation has occurred may submit a reasoned complaint to the relevant market surveillance authority. Such complaints are taken into account for market surveillance activities are reviewed following specific procedure established by these authorities. Subsequently, Article 99 of the Artificial Intelligence Act mandates the member states establish rule concerning penalties and other enforcement measures, which may include warning and non-monetary action applicable to violation of the regulation by operators. The penalties must be, of course, effective, proportionate, and decisive. They should also consider the interest of small and medium-sized enterprises, including startups, and their economic viability. Non-compliance can result in fines of up to 35 million or 7% of companies' global turnover, depending on the severity of violation concerning prohibited AI practice, operators' compliance with AI system requirements, and the scale or size of the enterprise. In the case of Council of Europe's Convention, signatory states will be required to implement its provision at the national level by introducing law and ensuring accessible and effective remedies for human rights violation resulting from AI system activities through their life cycle. This obligation includes the points mentioned on the slide. In summary, the Convention does not provide individuals with direct right to challenge violation before the European Court of Human Rights, whose jurisdiction is limited to the European Convention on Human Rights. However, individuals may still file complaints regarding violation of their rights related to AI system at this court, provided the national court have rejected their claim. In such cases, the Strasbourg court is likely to consider the principle enshrined in the specific legal document related to AI. At the end, the Council of Europe Convention and the European Union Act share common feature such as horizontal regulation and risk-based approach. However, the Act classify AI system by risk levels, whereas the convention focus on general obligation related to human rights and democracy. The convention will complement the European Union Act. Also, its approach is less specific. The EU aims to harmonize both instruments by promoting a risk-based approach and technical standards. The EU's position is negotiation with the Council of Europe is geared towards enhancing its global influence in AI regulation. And as you see, the AI principle by the OECD in 2019 have become a global benchmark for AI regulation. They have influenced ethical guidance from international organizations and governments, laying the foundation for human-centric law, data law, democratic values. What began as soft law, what began as soft law recommendation is now evolving into mandatory regulation to which the world should adapt. Despite various stage of development across countries, there is a growing alignment in approach to AI regulation, facilitating consensus building. This foundation agreement and consensus are not longer speculate outcome derived from comparison of national standards. They are now embodied the first international treaty on artificial intelligence. Thank you.
Так, чи можуть цю норму про виключення спецслужби використовувати для того, щоб використовувати штучний інтелект поза регулюванням європейського законодавства і конвенції?
Of course, I was taken about in my presentation, can use artificial intelligence system and avoid protect human rights norms. It's a very high risk for us, and we should concentrate our attention for this matter and create effective legal regulation in this sphere to protect human rights.
Thank you very much, Tatiana, for your brilliant presentation and for your answer. Maybe another participator have some question. You can ask a question in chat or in person. And I want to pass the word for our next speaker, Olександр Вишневський, Deputy Director of Institute Industrial Economy, National Academy of Science. Sorry for my translation, your position. Alexander,
okay.
Welcome.
Welcome. Hello, everyone. Did you see my presentation?
Yes, we see. Beautiful. Can you switch on, show the slides, please, for full screen presentation?
Okay, now. Okay.
Oh, great.
Did you see
Yes.
full screen?
Yes.
Okay. Hello, everyone. I would like to share with you some ideas about artificial intelligence, and it will be more on a theoretical and macro level, not low and practical. So, my topic is artificial intelligence as a core of the new industrial revolution, prospects and limitations. And first, I think it's all people who come to this meeting know we have really high expectation from AI, really high, and some auditors and consulting companies set about trillions dollar profit from AI annually. Big part of Fortune 500 companies mention AI in his reports. And we can see how last year was rising the market capitalization of NVIDIA, who create a special graphic processor which optimize the machine and deep learning tasks. And based on this, some researchers said about new era, where the core of industrial revolution will be super intelligence. But we don't know it will be or not, and we try understand why position which proves this mentioned and neglected. As we can see, last 2 years we have high rising of number of incident and hazards which close link with artificial intelligence is 0.1. And at the same time, if we see statistic 2023, we see the number of vacancies related to AI decrease to 1.6% compared to 2% year earlier. And the same situation with corporative investment in AI. So from on one hand, we can see the high expectation, and on the other hand, we can see some alternative position. Okay, and very big question which close discuss in research community. What does it mean artificial intelligence? What is definition of it? And as said Davidson, the terms artificial intelligence introduced by John McCarthy in 1956 is surprisingly poorly defined. And he speak about it 2024. And why? Other researchers try to give answer. It is not surprising that artificial intelligence is so difficult to define clearly. It is, after all, an imitation of simulation on something we do not yet fully understand yourself, human intelligence. So, I try to understand what does it mean artificial intelligence and try to use approach which was created by Aristotle more than 2,000 years ago. So let's try to see on these terms from 4 causes: material causes, formal causes, efficient causes, and final cause. Human intelligence. Material cause, brain; formal cause, structure of the mind; efficient cause, society, genetic, environment; and final causes, set goals and solve task problems. As we can see in artificial intelligence, we can find out some equivalence to these categories. Material cause, hardware, physical components of computer system and software. Formal cause, design of architecture, which units hardware, software, and data set into uniform system, i.e. system, as we can see later, used in legislation rules. Efficiency cause, human intelligence, for instance, engineers, environment, data sets. And final cause, solve task problem very often more efficiently and accurately than humans. But as we can see, artificial intelligence now not create, don't have opportunity to set goals. This stay only for human. And if we, based on a previous slide, try to understand logic of AI formation. So we have some general scheme. Hardware plus software plus dataset and the time to training. And we have AI. So this concept we can see find some reflection in legislation. And if a couple years ago, definition of AI in different countries was really different, but last 1 or 2 years, we can see to conversation, we can see conversion of it. And if we compare your Act 2024 and USA, President Act 2023, it's really close definition of artificial intelligence. If we look at the key elements as part of system, physical basis in Europe, machine-based system, input data, output prediction, content, recommendation, or decisions that can influence physical or virtual environment that are relevant to external objectives. And in US, almost the same. Physical basic, machine-based system, input, machine and human-based data, output, prediction, recommendation, or decision influencing real or virtual environment that are relevant to a given set of human-defined objective. So that we can understand the AI logic as a system. So we have input data set, we have some physical basic hardware plus software, where the training process and output, prediction, recommendation, decisions, etc. This information how to the next cycle, so physical or virtual environment. This create add information, add data to human knowledge, to human behavior impact, some smart controllers, and nature. And this process go to the next cycle. One next important things, as we understand now human race try to go from usual or close or near artificial intelligence to general artificial intelligence, which can replace human in every sphere of activity. And I try to understand the key characteristic to have a demarcation of this definition. And as we can see, if we speak about neuro artificial intelligence, environment for human training and environment for AI training, only partly have the same data sets. And if we speak about general artificial intelligence, the environment for human training will be only the part of environment for AI training. Based on the previous ideas, I propose AI prospects on theoretical level and on practical level. On theoretical level, first, alienation of tech knowledge from the individuals. Second, optimization of the planning system. Third, revision of the socialism calculation debate. And Fourth, decreasing information asymmetry. I not close attention to on practical level because of about it speak and write quite more and different publication. If we try to understand how artificial intelligence can influence on alienation on tech knowledge. As we know, Friedrich Hayek and other representatives of the Austrian School of Economic Theory show the key role of tactic knowledge in economy and highlight the significance of knowledge that is hard to articulate or codify. That is an intangible assets often rooted in personal experience and intuition. So that is difficult to formalize and so that we not create the plan economic system. But AI already has broad capabilities for alienated tech knowledge from people and use it for its own learning. Thus, AI can alienate and digitize human voice, speech, motion, and even brain activity. Second, big data and the enormous computing power of AI creates the conditions for improving the planning system and the micro and macro level. Simultaneously, time, cost, and are reduced. So, if you use thesis 1 and thesis 2, we can understand alienation of tech knowledge and optimization of the planning by AI created based for revision of the socialist calculation debate, one of the most wide and insightful debates in 20th century between the Austrian School of Economic Theory, Mrs. Hayek, and other, and Marxists, Dixon, Lange, and others, about the question of whether it was possible to rationally allocate resources and coordinate production in a socialism economy without relying on the market mechanism. Next, AI and decreasing information asymmetry. The expansion of AI use creates opportunities to reduce information asymmetry. For example, AI can be as an assistant for both the seller and the buyer. It can help the seller find the best sales channels, determine the target audience, and build a pricing policy. At the same time, AI can help the consumer find the optimal seller based on price quality criteria. The amount of information that AI has is significantly greater than the amount of information that both the seller and the buyer have. So, let us assume we have the information volume for seller and it will bigger than information volume for consumer. No, because of course, about products or service which seller try to sell, he know much more than consumer try to buy. But at the same time, information volume which have artificial intelligence much more and more than information volume of seller. And the same situation if we compare volume information of AI and volume of information of customer or seller. From 1 and 2 theses we have information volume of artificial intelligence plus information volume of seller. It is almost the same, the artificial volume and information volume of buyer. This is the use of the AI reduction information asymmetry. The same applies to other communication options. No, for example, when people communicate with government, yes, we have people plus artificial intelligence from one side, and from other side we have government plus artificial intelligence. So we have communicate and try to minimize asymmetry of information. And a couple of words about limitation of AI. First of all, many speaks about the structural long-term unemployment, but I think it's not problem because of from one side low wages. It's less economically justified is this implementation of AI, so it will be comparative game, and this alarmist forecast seems unlikely due to the fact that the introduction of new technologies always creates new jobs, the existence of which is extremely difficult to predict in advance. And we can see a lot of examples of these theses in the economic history. Next point. The second basic problem, which may manifest itself in the near future, is the extremely high expectation from the AI using in all spheres of society. As shown above, this expectation have led to a rapid growth in the capitalization of companies associated with the development of AI infrastructure and the products of AI products and AI services. If these expectations are not met, then not only the stock market, but also the entire global economy will face with a deep economic crisis. And I think it will be nearest year or two. Next one, third problem. The increasing use of artificial intelligence will require more and more electric power. This creates the risk that at some point the economic cost of energy consumption will exceed the economic benefits, at least in some cases of sector. Only in the future will we find out and take answer to the question, who is more energy efficient, human or AI? And last one, an additional question is the contradiction between the interest of individual businesses and the economy as a whole. For an individual business, artificial intelligence may not offer significant opportunities. Thus, AI for an individual business may not create fundamental advantage. For instance, the introduction of AI at the nuclear power plant is not capable of increasing its capacity. If the unit is decreased to provide 1 gigawatt per hour, it will not be able to produce more. It's physically impossible. But if we have many nuclear power plants united within a single energy system, then there is potential for optimized distribution using AI. And last two slides, its conclusion. First, definition of the artificial intelligence concept in the scientific community remains the subject of heated debate. At the same time, in the regulatory and legal plan, a trend is being formed towards unification of the AI concept, unification of AI concept, or a little bit tired maybe. And next, further improvement of AI, including the transition from AI to AGI and the expansion of its use, can make a significant contribution to solving problems related to economic calculation and minimization information asymmetry, and therefore optimizing transaction cost in the economy. And last one, artificial intelligence certainly acting as a locally useful tool at the level of individual enterprises and organizations, causes the acceleration of attracting funds to the stock market, which can lead to the formation of a Bible on the global level. If this Bible bursts, expectation about the economic efficiency of artificial intelligence will be reversed, and some AI-related company will experienced significant margin reductions, perhaps losses and bankruptcies. But this in turn will initiate the next stage of AI development, will accelerate its transition from the current narrow specialization to the creation of full-fledged general artificial intelligence. As a result, AI will become established as the core of the new industrial revolution. Thanks for hearing, and if you have any question, I try to give answer for you.
Thank you very much. Maybe we can start some discussion using that Dmytro Nikolaevsky now here together with us. Maybe as a general conclusion of our meeting, we'll speak about real perspective to Ukraine, looks for European perspective, American and British experience, see and wait, and in general understanding what, as a result of our meeting today, we should collect questions and our ideas for next events for, I hope in February we'll hold, and we're going to make great conference about digital economy and impact of cryptocurrency, virtual assets, and artificial intellect to our Ukrainian economy. So I will try to collect ideas from all and question and pass for some remarks and short question from Dmytro Nikolaevsky. And after this, we will try to answer for question from our chat.
Hello to all. I'm Dmytro Nikolaevsky, the legal lead and project office of Ministry of Digital Transformation of Ukraine. I can maybe give some my subjective thoughts about AI and connected with AI problems. But if it's possible, I can speak Ukrainian if we have a translator. Yeah?
Yeah, we have.
Super. Thank you very much. Тоді вже українською. Так зручніше, буде простіше викласти думки і якимось чином, можливо, задати нові питання для дискусії і для того, щоб ми це обговорили. Знову підкреслю, що маючи відношення до Міністерства цифрової трансформації, зараз я буду висловлювати мої власні думки. Вони близькі до офіційної позиції Міністерства цифрової трансформації, про які ми вже трішечки сьогодні почули. Вони викладені у відповідних документах, в тому числі був складений white paper з регулювання сфери штучного інтелекту. Відповідно, хотів звернути увагу на такі глобальні моменти, важливі моменти, які, можливо, цікаво було всім би обговорити. Мої особисті спостереження полягають в тому, що існує щонайменше 3 великі групи людей, 2 з яких побоюються штучного інтелекту відверто, внутрішньо. Я маю на увазі саме такі внутрішні глобальні переконання. І одна з груп, яка навпаки не побоюється і дуже зацікавлена в його розвитку. Побоювання зазвичай пов'язані з 2 основними моментами. Перший момент – це те, що людство вперше, можливо, має справу з чимось, що за рівнем інтелекту є вищим навіть за людський інтелект. Тобто є побоювання і очікування того, що вищий інтелект зможе створити якісь складні умови для істот нас, людства, як істот з нижчим рівнем інтелекту. Це такі дуже поширені, скажімо так, побоювання, оскільки ми не знаємо, що можна очікувати від інтелекту більш високого рівня. Інші дуже поширені, навіть ще більше поширені побоювання полягають з тим, що люди вважають, що штучний інтелект позбавить їх можливості заробляти власною працею. І це дуже чутлива історія. Звісно, ми маємо враховувати побоювання цих людей, але ми, як теж вже правильно зазначав хтось з попередніх спікерів, ми бачимо велику кількість історичних прикладів, коли технології розвиваються в людства невпинно, І відповідно з тим, що певні можливості, як робочі місця втрачаються, нові при цьому створюються. І ми також маємо мати це на увазі. Скажімо так, в протилежну позицію ті так звані tech-savvy people, хто цікавиться новітніми технологіями і питаннями розвитку, вони мають дуже сильний поінт, який полягає в тому, що фактично AI чи штучний інтелект – це інструмент, ще один інструмент, який людство отримало внаслідок власної наукової технічної еволюції. І відповідно, як інструмент, як будь-який інструмент, він може використовуватись як з певною благою метою, так і з негативною. Це ми бачимо навколо кожен день, багато разів. Автівки можуть причинити смерть, збивши нас на дорозі. Навіть кухонний ніж може стати знаряддям вбивства, ми це знаємо. Але ми маємо розуміти, що основне – це те, як люди використовуватимуть цей інструмент, і як ми, як люди, будемо впливати на інших людей за допомогою цього інструменту. Відповідно, є ще один дуже великий ризик. Я відношу себе до оптимістів, AI-оптимістів, і я вважаю, що, скажімо так, швидкість розвитку AI-технологій буде додатково прискорюватись. Чому? Тому що нові моделі штучного інтелекту, вони вже мають так звані можливості навчати самі себе. Тобто всі ті моделі, які існують вже зараз, вони опанували весь масив людського знання, а далі вони зможуть генерувати нове знання, навчатись, рефлексуючи на це нове знання, в тому числі вже згенероване самим штучним інтелектом. Відповідно, темпи розвитку можуть бути приголомшливими. Навіть ми можемо не бути готовими до настільки високих темпів. Які тут існують, на мою думку, додаткові ризики, саме регуляторні ризики. Ми бачимо певне нерівномірне регулювання по всьому світу. Тобто якісь країни приділяють більше уваги, намагаються більш рестриктивно віднестись до створення певних обмежень, захистити права і таке інше. Тобто аргументувати завжди є чим. Але по факту більш високий рівень регуляцій може призвести, з великою ймовірністю призведе до скорочення кількості бізнесів, проєктів, які будуть реєструватись в цих юрисдикціях, працювати в цих юрисдикціях і, відповідно, створювати потенціал для використання власних продуктів в тих юрисдикціях. І оскільки штучний інтелект може дуже прискорити і наукові дослідження, певні, скажімо так, хімічні, біологічні, медичні, то, відповідно, ті юрисдикції, які ввели жорстке регулювання, можуть бути позбавлені фактично можливості швидкого наукового розвитку. І ми зможемо побачити дуже швидкий перерозподіл сфер впливу по всьому світу на користь тих країн, які впровадять для себе найменші регуляторні обмеження, оскільки інновації будуть найбільш ефективно розвиватись саме там. Саме тому я й кажу, що мені дуже подобається зважена позиція Міністерства цифрової трансформації, яка полягає в тому, що ми дуже уважно дивимось спочатку, не відразу вирішуємо, а спочатку дивимось, що ми, і це, можливо, трішечки залишилось за лапками, але я ще хотів цей важливий поінт додати, ми дуже важливі ставки робимо взагалі на сферу освіти, технічної освіти, технологічної освіти. Ми хочемо зробити так, щоб все більше людей розуміло взагалі потенціал, розуміло інструмент, як ним можна користуватись, і, відповідно, як можна і треба уникати можливих зловживань з боку інших осіб, хто користується відповідним інструментарієм. Тобто освіта – це взагалі є ключовий поінт в аспекті регулювання. Навіть якщо припустити, що регулювати треба і мають бути чітко визначені певні обмеження регуляторні, то навіть для того, щоб ці обмеження грамотно сформулювати, потрібен певний технологічний бекграунд від людей, які пишуть цей закон, тобто від законодавця, від експертів, які будуть допомагати законодавцям виписати відповідні вимоги. А це так само є результатом певного освітнього рівня, наскільки люди розуміють взагалі в тому, що вони роблять. Дуже схожа, до речі, ситуація спіткала нашу галузь віртуальних активів. Тобто все те, що є новим, все те, що є цифровим, існує в віртуальному світі. Тобто інтернет, він не має якоїсь чітко визначеної юрисдикції, і відповідно сфера дуже чутлива до регуляторних впливів, і бізнес дуже швидко може міняти свою локацію в залежності від того, де умови будуть більш сприятливими. І врегулювати цю галузь так само складно, бо крім того, що створюються певні правила законодавцем, ми ж маємо розуміти, що закон не може бути пустим, порожнім, він має ще виконуватись. Тобто мають бути певні органи виконавчої влади, які зможуть достатньо професійно забезпечити виконання, покарати за порушення. А це все теж є умови для цього, так само створює освіта. Тобто людина, яка не розуміє, про що взагалі йдеться, вона не зможе займатися вже на стадії правозастосування, застосуванням відповідних правових норм. Може це призвести до певних також негативних випадків щодо, скажімо так, судової системи. Тобто суддя, виносячи рішення, постановлюючи рішення по справі, в якому предметом спору є питання, пов'язані з використанням штучного інтелекту, так само має мати певний рівень обізнаності. Звісно, що він не досягне рівня експерту в штучному інтелекті, але базові знання, базове розуміння того, як це побудовано, як це працює, розуміння того, що технологія передбачає певний блекбокс, тобто частину, яка взагалі навіть самі розробники не можуть пояснити, що відбувається. До речі, в цьому є дуже велика схожість з тим, як працює людський інтелект. Ми теж не розуміємо, але і не регулюємо взагалі питання, як ми маємо користуватись власним природним інтелектом. Тож освіта і певний час, протягом якої цю освіту ми зможемо здобути, оце і є, на мою суб'єктивну думку, запорукою того, що регулювання, до якого все одно ми прийдемо, бо будь-яка сфера людства, яка стає поширеною, достатня для того, щоб впливати на життя мільйонів людей, вона так чи інакше приходить до регуляції. Але питання, яким шляхом ми прийдемо, який корисний імпакт ця регуляція буде мати, і чи не створимо ми при цьому, при розробці цієї регуляції перешкод для подальшого глобального розвитку, відновлення країни вже після завершення військової агресії проти нашої країни. Тобто дуже важливі моменти, дуже цінні інсайти сьогодні від багатьох експертів. Дуже за це дякую.
Thank you. Thank you, Dmytro, for so wider answer, and you cover all question what we had before. I want to pass for our I want to pass word to our big friend of Ukraine, Basil Maniosos. He is now in Romania, but actually he is working in Edinburgh as Cyber Academy international level cyber expert, and also working in field of education, and share our expertise for all world, mainly in data and forensic and digital forensic, cyber forensic. So Basil, please, a few words about what you think about artificial intelligence. It's help to us and main facilitation in these fields, and main challenges for us, for your opinion and your expert experience in working with different law enforcement, for forensic in criminal cases as well.
Thank you, Alexander. Thank you for inviting me and having me with you. As you said, I'm a friend of Ukraine and always happy to help, especially with the legal profession. We've done quite a few training and awareness things before. As Alexander said, I'm working as a manager of the Cyber Academy at Edinburgh Napier University, but I'm here as an expert witness. I'm on computer forensics and digital evidence, and I work very close with the legal profession. I work very close with the Law Society of Scotland. I have actually developed their cybersecurity training for lawyers. So that was a very interesting and challenging work. And I also work the last few years with Interpol and some other organizations, all in the field of digital evidence. So there's a few takes on the issues. I've got some slides. Do you want me to put the slides on? Would be better?
Oh, it will be brilliant. Yes, if you can.
Yep, I'll be happy to do that. Just start. And let me just share this. So can you all see my picture?
Oh, brilliant.
Yeah.
Court session or sheriff court where it's right.
Yes. It is a real one. It's not created by DALL-E. No. Yeah, I was trying last night to create a picture. This was the best thing I could actually get for a Scottish court. So I said, okay, I was too tired. I'll just use this one. So there are several things that legal professionals are dealing with when it comes to the artificial intelligence. And the first of all is understanding what is AI in general and understanding what that LLM tools, large language model tools are, what they can do and what they cannot do. And understanding their limitations is a big problem. So lawyers understand that this is the future, that AI technology is going to be embedded in their work, but they're not really sure about how things work. And some of them are very skeptic about using it, and rightly so. So you've heard in the case in the United States last year, a lawyer prepared, paper for the trial, and it turned out that ChatGPT created a fake case, and he submitted it to court, and he was ridiculed professionally. But a large language model that is only trained on laws, on legal proceedings, on precedents, that is not looking around the whole of internet, but is looking, let's say, at each country's legislation, EU laws, and international treaties and stuff like that. That's going to be a much more accurate tool to use. Of course, there's a problem there. And I see the problem in the United Kingdom. The United Kingdom has two jurisdictions, as Alexander knows. Scotland, that is using Scottish law, and the rest of the country that is using English law. And these are two different legal systems. And if you have prepared an LLM model that is to be used in the United Kingdom, and it has both legal systems in its training, it might be difficult to differentiate at some point what is English law and what is Scots law, and you might get confusing answers. And the confusing answers are not going to be fake like we see now with hallucinations, but it could be a problem of distinguishing between the two jurisdictions. And that is one of the problems. Lawyers and legal professionals, they have a lack of a deep understanding of the technical workings of AI. They don't always understand the limitations. And I have to say that lawyers are getting better where prosecutors are not. And the thing is that lawyers have the luxury of time, and usually, you know, big law firms, they can invest on money and training and help their people better understand, where the prosecution services do not have that. They have small budgets, they have backlogs, and things are left behind. There is a skepticism about AI's lack of accountability. So if I'm an expert witness, I go into the court, I give an opinion. If I've done something wrong, that's me. You have Basil to blame. If my opinion was not right, or if I said something that was not factually correct, then I'm accountable for that. What happens when the AI has come up with an expert opinion? So the other thing is that legal professionals will look for AI for repetitive tasks and mundane tasks, but they are still skeptical about using it for high-level legal work. Legal and ethical issues related to AIs in the court. One of them is actually the issue of discrimination, where AI algorithms can discriminate against people. And that's going to be because of a bias. But the bias is something that the creators gave to the tool. The tool in itself is not inherently biased. It's the training that they had that is biased. And if it's trained properly and over time, and the biases are identified and fixed, it can be more objective than humans. And there's the issue of transparency, where people do not understand where things are coming from when AI is involved, and that raises the issues of a due process. And as I said, accountability. There is other issues like data privacy and autonomy of judges and lawyers. And some people think that if AI is more involved in judicial decision-making, it would erode the independence of human judges and lawyers, and where the courts will be relying heavily on technology for guidance. Again, this is something that you can put into order and have measures in place to make sure that it doesn't happen. How you do that? You just don't let AI to run the court. You use AI as a tool, the same way you use a search engine in a library to look for legal documents. The same way you are using every other tool. We are using AI for years. Before, most people think of AI came up 2 years ago when ChatGPT was made available to the public. No, ever since you had Microsoft Word and you had a check spelling and a dictionary, and the dictionary would find you, use a thesaurus and would find you alternative words so you can make your text better, that was AI. I've been using Microsoft Word for more than 20 years. Okay, that's your AI there. It's not something new. It's that the LLMs, things like ChatGPT, change the level of the game. There was one case, the COMPASS case, that stands for Correctional Offender Management Profiling for Alternative Sanctions. It's just say COMPASS, it's easier. And it's been used for sentencing in the United States. And it was an interesting tool because you would feed all the information of at the end of the trial, and it would come up with a sentence based on the sentencing guidelines. And again, this is a tool. However, it was actually used, and it was then, at the time, it was challenged in court. And it was a case called State v. Loomis, where there was a challenge of the sentencing. And Loomis argued that the algorithm violated his due process rights due to its lack of transparency and potential bias. They did not prove that there was a bias or there was a transparency issue, but what often happens with police evidence is that the other side, the side that accuses, cannot prove that this did not happen, which is equally bad. So there were concerns about the use of AI or the over-reliance of AI in such decisions. And it highlighted issues related to bias and opportunity. There was an opportunity to challenge the algorithmic decisions in court. Now, that happened in 2016. From 2016 until now, many things have changed and have changed fast. Technology is never perfect, and it's always updated, always fixed. You know, there's always bugs, there's always mistakes that were in the initial version of every piece of software. And as time goes by, those tools will get better and better. It's up to us to make those tools better first. And also, it's up to us to decide how we use that. Okay, if you just leave the AI tool to pass the sentence to a person, that is inherently wrong. But if you use it as a tool for a judge, and let's say the conviction for something very serious is 25 to life, and the judge is thinking 25 to life, and the AI says 25 to life, then those two coincide, and it shows that the AI tool was very close to what the judge was going to give. But if the judge was going to give months in prison and the AI says 5 years in prison, there's a big discrepancy. One of the two has made a mistake. And it might have been the judge, because the judge may have missed something, depending on how experienced they are. But in that case, you know, it is obvious where it is. And small discrepancies, like the judge can say 15 months and the AI will say 14 months. Okay. Again, it means that the judge needs to go back to the books, to the sentencing guidelines, and see who is more accurate. Okay, did they miss something? Did they let their own feelings, you know, interfere with the decisions? So it's always important to look at AI not as someone who will replace the judge or the prosecutor or the jury. It's a tool. Okay, in the past, we didn't have TV screens in the courts. Now we have. We didn't have video walls. We didn't have microphones. We didn't have digital recorders. Now we have all those things. People were not happy when changes happened, but they did happen. Now we just take those things for granted. There were some limited trials in the UK, nothing as extended, and you know, everything was at a research level. So the AI tool was not directly used for convicting people and sentencing people. But what turns out from all those trials is there's a lot of work needs to be done. And it's an interesting thing, because if you develop something for the American legal system, where you have 52 states and every state has a different legal system, you need to adapt the model for every state. And then you need to adapt it for a federal court. Then, if you come to the UK, you need to adapt it for English law or for Scots law. Okay, you need to make sure that it's not just the technical part, you know, the text of the legislation is there, but also the processing of that legislation is proper. And when it's coming to adopting AI for handling digital evidence, we already use AI in electronic discovery, which automated the discovery. So you have, you know, 1 million pages in PDFs. Okay, who's going to read that? Okay, and you can start looking for keywords, but you put a large language model, upload all those documents, and then they can make correlations, very, very fast. And they can help you search through the 1 million pages where only 20 or 30 pages are of evidential value. And this happens a lot in civil courts. When there's money involved and big law firms and stuff like that, disclosures end up being, thousands or hundreds of thousands of pages. Why? To make it hard for the other side. And AI is going to simplify those things. AI is also very good at looking at patterns in digital data. So let's say ChatGPT, it's a large language model. Using ChatGPT to find things in 100,000 of digital pages of text is what they were made for. They're going to be faster than humans. And then the humans, when they got the results, they'll have enough time to verify the results. The thing is that if it takes the humans 3 months to go through all that data, then you need an extra time to verify the job that was done in 3 months. Now you do everything, in 2 minutes or 3 minutes, and then you verify the results the next day. It saves time. And there's issues when it comes to digital evidence handled with AI. There's issues about understanding and hesitation. There's hesitation among legal professionals who may lack the technical expertise to fully understand how AI analyzes data. And new digital forensic tools are now embedded with AI processes, and lawyers are challenging or can challenge those things, but they challenge mainly because they don't understand, not because they understand and see something wrong, which is a very interesting proposition. Okay, you challenge something that you just don't understand. And this is the issue of training and awareness for the legal profession. And judges are also cautious about admitting evidence that was analyzed by AI. However, in a courtroom, the final decision lays with the judge. And if the expert witness who's presenting the evidence explains properly why AI has not compromised the evidence, and it was just more efficient to do it that way, then it's normal to expect that the judge will accept that and the case will go on. Judges, in my personal experience as an expert witness, they will take more time to think about it when they're not sure, and they will ask for additional advice. Where prosecutors are like a meatball factory, they try to prosecute as many people as possible and get their numbers up. That's the very big difference. There is also the misunderstandings of often judges and lawyers may misinterpret AI result as more accurate or more definite than they are, okay, without taking into account possible biases. But they also may do the exact opposite. Because of their own biases, they may misinterpret the evidence, and they can consider that it is not as reliable as if someone had actually done the work manually. So it's a double-edged sword. That's why we need again to train and educate and create awareness in the legal profession, because all those things that I just mentioned are just going to hinder legal proceedings. They're going to create more backlog. They're going to slow down the delivery of justice. And they're just going to, instead of making things easier for everybody, they're going to make things harder. And I guess these are the points I had to make.
Thank you, Basil.
I'll
Thank
stop
you.
sharing, and happy to answer any questions or discuss anything you want.
Thank you very much for wider show to us your experience and really very informative slides from your expert experience, because you're working all the time with judges and lawyers, understand our main mistakes. And we are just to try today find question and call it question for our future events, including with basal participation and support for forensic experts, for Ukrainian advocates as well. So thank you all for brilliant event. Waiting for our next event in series of digital economy together with Institute of Economical Legal Research of National Academy of Science, named Valentin Mamutov, National Academy, National Bar Association of Ukraine, and with Basil Manosos, and also with Clark Foundation for Legal Education, who support our cross-border sharing of education and information. So
thank you for inviting me, and always happy to participate in your events. And if anyone wants my contact details to discuss this or anything else related to digital evidence, which is my expertise, I'll be happy to get in touch on LinkedIn or through email. Find me on LinkedIn or ask Alexander for my details, and I'll be always happy to help.
Yeah, and Basil open our future plans and show perspective where we're going to provide series of special courses about digital forensic, crypto forensic for lawyers, for Ukrainian lawyers, together with top-level international experts. But I hope it will be November, December, when we have finalized our digital economy series. So thank you for joining to us. Thank you for hearing our event. So if you have some question, you can contact with National Bar Association of Ukraine and with me. So thank you. See you. Have a nice day and have a safety day in Ukraine.